Looks like everyone is ready. We are now ready for Feeback versus Swift Pork. I believe it's Ruth Horvatich. Did I pronounce it correct? Thank you.
Chief Justice, may it please the court, counsel? My name is Ruth Horvatich, and I represent the Appellee's defendants, Swift Pork Company, Troy Mulgrew, and Todd Carl. The application for review was granted with this court based upon our application to reverse the Court of Appeals decision, which reversed the district court's grant of summary judgment relating only to the age discrimination claim brought by Mr. Feeback. The Court of Appeals erred in the following ways. First, by reversing the district court's determination of the admissibility of evidence of other employees allegedly terminated due to their age. I'll refer to this evidence as the Me Too evidence. Second, the Court of Appeals erred by considering comparator evidence of employees that were not similarly situated to the plaintiff, Mr. Feeback. And the Court of Appeals also erred in improperly substituting its own judgment for that of the company relating to the company's reasoning for Mr. Feeback's termination in this case. With our application, we are also requesting that this court resolve the appropriate standard to be applied at the summary judgment stage of Iowa Civil Rights Act claims.
Should we keep the McDonald-Douglas test?
Yes, the defendants would propose that the McDonald-Douglas burden-shifting framework remain when there's not direct evidence of discrimination at the summary judgment stage. This is
Don't use it at the trial stage. There'd be a disconnect between what the jury would be deciding, and I mean, why have a different test at summary judgment?
There would not be any sort of differential treatment there because this is actually what the Eighth Circuit model jury instructions do for Title VII cases, which is the statute that the Iowa Civil Rights Act is modeled after.
Stands alone in continuing to follow that, is that right?
I am not aware of what other circuits are doing with that, but the Eighth Circuit in its instructions does instruct on a motivating factor standard for the jury instructions, but considers the McDonald-Douglas burden-shifting framework.
Courts, if the Eighth Circuit does stand alone and the other circuits actually use a different test, should we adopt a different test used by those circuits?
I would maintain that you should adopt the test that is used by the Eighth Circuit.
I think you argue you're entitled to summary judgment either way, right?
We absolutely argue that we are entitled to summary judgment either way. And really, at the pretextual stage of the McDonald-Douglas burden-shifting framework, the question is the same as the motivating factor test, which is
Kind of the issue. McDonald-Douglas talks about pretext, but if the standard that we're applying is motivating factor, what do you do in a mixed motive case where there might not be any pretext? I think that's kind of that's where the oddity comes from. The McDonald-Douglas is actually a single factor test that applies when there's only one real reason, and then the real reason is a pretextual reason that's offered. So what do we do with the final step of McDonald-Douglas talks about pretext, and you can very well have two reasons so it might be a mixed motive case rather than a pretextual case.
Could you speak a little closer to the microphone, maybe bend it down a bit? There you go. Thank you. They're having a hard time picking up your voice.
At that stage, both at the time, there's true question is whether or not there is intentional discrimination. And so I submit at the pretextual stage of McDonald-Douglas, that's appropriate at the summary judgment standard. There, the court is determining whether there is an issue of fact for a jury to decide. Now, under the motivating factor, the jury is going to make that determination. And so they should be instructed on that motivating factor standard consistent with what the Eighth Circuit does.
Understand your position. Your position is there's no evidence that age entered in at all into this case in the decision to terminate Mr. Feeback. Is that right? So it doesn't really matter what the standard is, and we can figure it out if we can work on it if we want to, but it wouldn't affect the result in this case, at least in your view, right?
Yes, that's absolutely correct. It will not affect this case because we prevail under both standards in our position.
So in correcting the summary judgment standard, it seems like there are two ways we could do it. I mean, we could adopt a different summary judgment standard, or we could fix our causation standard, right? I mean, that's the problem, is that McDonnell-Douglas doesn't reflect the causation standard but for. It does reflect that, but then motivating factor kind of creates a different causation standard. I mean, couldn't we just go back to our but for causation standard? And that would also require then application of McDonald Douglas, right?
Yes, I think the ultimate question is right now in Headland, this court confirmed that it hasn't touched the summary judgment standard, but it did change the standard at the jury. And since that case, lots of courts have been applying both standards. And I believe thus far, the cases really have come out the same under both standards, and that's also true of this case.
Was there a culture of profanity at the meatpacking plant, and does that help get the plaintiff to a jury?
To what the Court of Appeals found with that comparator evidence, seeing it more as culture type of evidence, I would submit that that is a wrong standard, and that doesn't get to the ultimate question of whether or not Mr. Feeback was terminated due to his age. And that is why we would urge this court to adopt the similarly situated standard that's utilized by the Eighth Circuit and many other circuits with respect to this type of comparator evidence. If you're just looking at the plant as a whole and you're not looking at specific supervisors that supervise the employee, the plaintiff at issue, comparators, it doesn't work to point to age discrimination. While it might point to an unfairness of a decision, it does not point to age discrimination.
A clone?
Be a clone. I think, of course, that the clone language really comes from misconduct, which this case does involve misconduct, and where you're probably not going to find exact types of misconduct from different employees. But the supervisor is a pretty important one that you do want to be very similar, and you want them to be in similar positions. Mr. Feeback here was a superintendent at the plant, a pretty high position, and so he could be held to higher standards than the other employees.
What do I make of Mulgrew's testimony that he wasn't exactly sure if the texts were directed to him? There might have been some mistake about the recipient. What am I to make of that? It seems, I guess, a little bit odd. As I read those texts, it sort of makes sense, I guess, in light of what happened at work earlier that day. But he testified himself that he thought, oh yeah, maybe this was perhaps not sent or not intended for me.
Later on in his deposition, Mr. Mulgrew did testify that he did believe they were for him, but he did say that the second text message, there was the FU text message, and the second one, believe who and what you want, he wasn't quite sure what Mr. Feeback was referring to there. But when he sat with it, he knew that those text messages were meant for him. And additionally, Mr. Charbonneau, who is the HR representative for the company that actually made the decision here, he spoke with Mr. Feeback, he spoke with Mr. Mulgrew, and he spoke with Mr. Carl that was present for the earlier conversation, and he made the determination that he believed that that text message was meant for Mr. Mulgrew and did constitute a terminable offense of misconduct.
That we need to resolve the issue, but in his own affidavit, Mr. Feeback says that Carl tried to turn Mulgrew against me by saying things that were not true. And then Feeback sends the text that says, F you, believe who and what you want. The second sentence actually makes sense in the context of what Mr. Feeback was saying, but maybe Mulgrew wasn't woodshedded enough for his deposition. I don't know. But, I mean, do we need to even resolve that?
Be resolved, because that's another standard that I'd urge this court to adopt, which is the good faith belief standard that the Eighth Circuit also uses when an employer is investigating this type of misconduct. Now here, the only evidence that is disagreeing with whether or not that text was meant for Mr. Mulgrew is Mr. Feeback himself. And there's plenty of cases, including Iowa Court of Appeals cases, that recognize that that's not enough to show discrimination. That's not enough to survive summary judgment. And there is no dispute that the evidence shows that the company did have a good faith belief that that text was meant for Mr. Mulgrew, and the decision was appropriately made for his termination. No evidence of discrimination.
Is there any evidence that anyone else told the plant manager, Mr. Mulgrew, said F you to him and kept their job?
There's no evidence at all on the record that that was directly made to Mr. Mulgrew by any other employees.
does the record support a finding or an inference to create a jury question that there was a pattern of forcing out older employees?
The record does not, because the evidence that was submitted by Mr. Feeback is inadmissible. And the district court got that right, and that's where the Court of Appeals got it wrong. I mean, first of all, the Court of Appeals didn't even use the appropriate standard for determining that evidentiary issue. You can't even tell what standard they use from their decision, because it's an actual abuse of discretion standard when that district court makes an evidentiary finding. The only evidence that the district court found inadmissible was this Me Too kind of pattern and practice sort of evidence. And that evidence, additionally, as we argued to the district court and to the Court of Appeals, is directly contradictory to Mr. Feeback's testimony in his deposition, where he went through the same employees and admitted that he had no firsthand or personal knowledge about the circumstances of those terminations. And so the inference that Mr. Feeback wants to make with listing out these employees that had separated employment and were over the age of 40, you can't get there when he doesn't have firsthand knowledge or personal knowledge with respect to why they were terminated. You have to assume they were terminated due to his age to make the leap that he's terminated due to his age.
If he had, this gets back to McDonald Douglas, if he had statistical evidence that there was a disproportionate tendency to let people go who were older as opposed to younger, if they had, you wouldn't need to have first-hand knowledge of why any particular person was let go, right?
More of a disparate impact sort of case. In this case is only pled as a disparate treatment case. And if it was a disparate impact case, we don't have those statistics. We only have the certain employees that Mr. Feeback identified. We don't know how many other employees of different ages may have been terminated during that same time period.
In comparison to the other individuals, the only evidence of age discrimination in the case?
I would argue that that evidence is inadmissible, and that is the only evidence about the age. Now, Mr. Feeback does attempt to have a laundry list of employees that he alleges had said F you or other cuss words to superiors at or in front of them and were younger than him and were not terminated. That's the comparator evidence that I refer to, that I believe we need to hold him to a standard of similarly situated in order to show that that's evidence of age discrimination. That's the culture evidence that the Court of Appeals considered.
Can
That about age?
No statements about age in this case at all.
about his retirement plans?
Our retirement plans or anything to do with his age.
Affidavit point as to these other employees that were older and forced out, any statements about their age?
No statements adverse to age in this record at all.
Can we draw an inference from how brief the investigation was?
That there's no law that requires a company to perform any sort of investigation. The investigation here, I think that's when you're entering the business judgment of the company, and here that's inappropriate with what happened. It's a pretty straightforward case that he texted his superior at one of the highest persons in the company, F you. It doesn't require much of an investigation, and the investigation really shouldn't be in question because there's no evidence that it wasn't investigated. Rather, it's undisputed that Mr. Charbonneau interviewed all of these individuals and made a decision. Now, I think this is a little different from a performance case where you have a case where someone is terminated for performance and you'll see evidence where they maybe got a lot of good performance reviews and it doesn't support it. But here, it's not the same type of case where you can question it. And the only person, again, that's questioning this is Mr. Feeback himself, and that's not enough to survive summary judgment.
Hypothetically, if we decide to abandon the McDonnell-Douglas test, would we have to send this back for a do-over on the summary judgment motion, or can we decide whether to affirm based on the record before us?
Whether to affirm on the record before us. I did just want to touch on the business judgment rule. And just add that is something that this court, I believe, should adopt, especially in light of the misconduct in this case, and that the Court of Appeals inappropriately entered into the business judgment of this case with respect to questioning the investigation when this is much different from those type of performance review cases. And again, with a similarly situated, I admit that it doesn't necessarily have to be a clone, but here we have no information with respect to those comparators. We have no evidence of what positions they held, who they were supervised by, who they made the statement to, and no evidence of the circumstances surrounding that conduct.
Judgment rule, is that the same thing as an honest belief or the good faith belief that he was insubordinate?
Hand in hand. So this court has recognized the business judgment rule for employers, but I think that we need to go one step further, and we request that you adopt the good faith belief standard for situations as in this case. Thank you.
Thank you. Mr. Stoltze.
Thank you, Madam Chief Justice. Supreme Court, Counsel. My name is Bruce Stoltze Jr., and I represent David Feeback, the original appellant in this case. To begin with, while I do agree with a lot of the recitation of the status of the case that my esteemed counsel has said, I want to point out that somebody is questioning the investigation. The Court of Appeals questioned the investigation. This is on further review. The Court of Appeals did in fact question whether or not that investigation was done. And they didn't just question, as counsel would have this court believe, the business judgment rule. They did not sit in the seat of a super personnel department. They looked at all of the circumstances. There's the fact that there was a conversation between the supervisors before the investigation took place that indicates that the investigation was already rigged. Text message said, Feeback not allowed to return to work, and the other supervisor returned a response saying, amen, indicating we want him gone, and it's time he's gone. Then, sorry.
I wonder if they had done further investigation, how that would have uncovered any information helpful to Mr. Feeback. I mean, did he ever explain, hey, I mean, I know he said he didn't, he says he didn't mean to send it to the boss, but did he ever explain why he was sending it F you to his friend and believe what you want to his friend?
Actually devoid of some of that and not some of it, Justice Waterman. The fact is that he did explain to Mr. Charbonneau who he meant to send it to and that he accidentally did send it. And he explained that the reason he didn't talk to Mr. Mulgrew right away was because that this happened right away in the morning. A jury can infer different facts, and the fact of the matter is that when somebody mistakes a text, one inference is there might be embarrassment to deal with it right away with the same person. But that's also part of this investigation, is that when Mr. Charbonneau met with him, he was told this alternate. Mr. Charbonneau refused to investigate any further, put him on suspension, and a couple days later he was terminated. There's a question as to a good faith belief. Well, how about the idea that you kept a guy on suspension pending an investigation, but you didn't actually investigate anything?
Your arguments sound good to me if, I was a labor arbitrator and Mr. Feeback was under a collective bargaining agreement and he was grieving his termination. But in this case, I mean, the Court of Appeals says there's a fact question about who Feeback meant to text. That isn't really the question. Isn't the question the issue whether there was a fact question as to the grounds on which he was terminated? Was he terminated for texting profanity to his boss following a meeting where he was was dressed down by his boss?
Justice Mansfield, I think both are true. I think there is a fact issue as to who he meant to send the text to. The defendant, the employers in this case, still contend he meant to send it to Mr. Mulgrew. But the reality is, yes, the real question is the fact issue of, was their termination legitimately because he sent that text message, or is that really just a pretextual reason? And by looking at this totality of what's going on, The Court of Appeals agreed, this doesn't seem right. A jury could infer this is pretextual. That's kind of where the idea that, first example, like what counsel is going through, there is a laundry list of other employees who are going through, who are swearing as supervisors and they weren't let go. That's been sworn to, that is something that is in the affidavits. I wanted to point out one additional affidavit allegation that's been made by superintendent, that was made in paragraph 27 of his affidavit. Mr. Feeback said that Superintendent of Slaughter, Rod Lant, who was 15 years younger, was screaming and cussing as a supervisor, and then he was not terminated and ultimately was retired. When we're talking about comparator type evidence, same title, superintendent, same level, swearing to a supervisor, insubordination.
Mulgrew, though, isn't he the overall plant manager? Isn't that a higher level? So it'd be worse, I would think.
Is true, and that may be what's going on, but that is why there's a fact question gendered here. That's one of the problems with the similarly situated test that the 8th Circuit has enunciated, and that's why I'd rather go, Your Honors, there is a split if you look at the 11th Circuit and the 7th Circuit, as the Court of Appeals pointed out. That's not a universal rule. And as the 7th Circuit pointed out, in Johnson v. Advocate Health and Hospital Corporations and 892 F3D 887, they said it's a flexible and common sense and factual. There's no magic formula. Then the employment context, the requirement is to find a similarly situated comparator is really just the same requirement that any case demands. The requirement to submit relevant evidence. Relevant evidence means having an tendency to make a fact more or less probable than would be without the evidence.
Your position here that sending a text message to your boss that says, F you, believe who you want, is not enough to fire that person, if true?
I think it could be. I think under the Supreme Court precedents for unemployment cases, for example, that would fall under insubordination. I think that also begs the question here. You hear this in cases often where that if you have the right to terminate somebody without enunciated reason, but you choose to do so, you are undertaking an obligation for that. There's no duty to have investigated this. But since they chose to investigate it, then you look at the method that they chose to investigate it, and if they do it, and if they're cutting corners, if they're doing it in ways they wouldn't normally do it, that's evidence of pretext, Your Honor, Justice.
Is it appropriate for them, for the investigator here, to have said, Mulgrew, I know you, you're both telling me kind of different stories. Mr. Feeback, you're telling me, that you didn't mean to send it. I don't believe you. You're fired. Sounds to me like that's kind of what happened. He did talk to everybody, right? He talked to Mr. Feeback, and it just didn't believe him.
Justice McDermott, I don't believe he talked to everybody, and that's part of the problem. First of all, I talked to Mr. Mulgrew, and Mr. Mulgrew admitted maybe text message number 2 was meant for somebody else. And I understand that there's been questions in the council seem to indicate other people may think it does fit, but that's the whole idea of a jury. Reasonable minds can differ, and that's why we need a jury to resolve those disputes. The fact of the matter is he didn't talk to everybody else. He specifically did not talk to the person and did not follow up and did not even look at the situation of who the text message was meant to go to.
Relevant if there's other evidence that would demonstrate this reason is pretext. So you've identified the fact that other people cursed at other people, not Mulgrew. What other evidence is there of age discrimination in this record?
Well, on the record, there's multiple evidence. For example, he worked there for 30 years and had good performance reviews during the most of that time. There was one moment where he was demoted and then he was brought back up. Interesting, in this case, there was a question about whether or not there were some bad performance reviews, but apparently their computer systems failed and those bad performance reviews just disappeared. But as the evidence sits, good performance reviews, long-term employment. Then you have the fact that it was only recently that his criticism started as he got older in age. Then there's also the other evidence of older employees being pushed out. And I understand from counsel's questions about whether or not that evidence is admissible or not. Obviously, we believe that's admissible. I believe, Your Honor, Justice McDonald, it proves that there is a culture of age.
Employees are in the plant.
I believe so. I believe it was like 2,500, Justice McDonald, but I don't remember off the top of my head.
Employees in the plant.
Retention.
People are fired in the plant.
Do not have that information, Justice.
We don't know the denominator. What inference can you draw from the fact that you have anecdotal evidence of some older people being fired? I mean, all that is proof that some other people got fired. Not, you said it's evidence of ageism, but you can't say that if there's 1 million people there or 10,000 people there. So without that, what inference can we draw?
Justice, there'd be two things I would say to that. One, in his affidavit, Mr. Feeback actually made a pretty strong statement in his affidavit that called into question on paragraph 22. He said, nearly 30 years with the company, I would estimate that I've worked with hundreds of employees in supervisory and management roles. Of those employees, I can only recall 5 or 6 employees who retired with the title of manager, 3 or 4 employees who have retired with the title of supervisor, and only 1 employee has retired with the title of superintendent. Some's anecdotal, this is not. This is his awareness of having worked there for 30 years. It's his own it's his own analysis. Now, the other thing, Your Honor, Justice McDonald, is that, as the Court of Appeals pointed out, that if the reason for firing a plaintiff is false, that creates an inference of discrimination too. They're the ones who can put forth the best evidence. And in this case, they did fire Mr. Feeback for a false reason. They didn't fire anybody else this way. They allowed swearing to go rampant. Even Mr. Mulgrew agreed it. I understand that there may be a difference with the fact that Mr. Mulgrew was the plant manager, and perhaps that creates a different scenario. But that's what the same decision defense is all about. The defendant gets to go in and argue to the jury, we would have fired him because, yes, we understand swearing's going all around, but we still would have done it because it was to the plant manager. And then the jury gets to sit there and go, that doesn't sound right. We don't believe you.
The same decision defense is we considered an impermissible reason, age, but we would have made the same decision. It's not some pretext about whether or not he was fired for this. He was undoubtedly fired for this.
I stand corrected. On the other hand, that is what motivating factor is about. And that's what allows them to argue this. There could be more than one reason, as long as it plays a part. And that's what the Civil Rights Act is meant to do. It's meant to stop discrimination in the workplace. Not just, as it was said in Hawkins, not just to create a procedural way to resolve a dispute. The fact of the matter is that this could very well be that case. They've presented some evidence. We've presented evidence that showed the contrary. And that's why the Court of Appeals was right in saying it doesn't just pass motivating factor, but it also passes McDonnell Douglas.
Does the contradictory affidavit rule come into play? Because in this deposition, he was questioned name by name and then would say, I don't know why, or I don't have any personal knowledge. And then in his affidavit, there's a list of names of older people who were, in his view, forced out. Should we apply that rule to set aside his affidavit?
I understand the question, and my answer is kind of multifold. First of all, we have argued that they didn't preserve this for appeal. This wasn't brought before the district court.
They won summary judgment, so they're appellee. Our rules don't even require an appellee to file a brief. I mean, did they argue in district court that they fired him because he was insubordinate? Is that enough to preserve error if it comes up?
I believe that they did need to bring it up in front of the district court. They did prevail in district court, and so bring it up to the Court of Appeals they didn't have to do. We first found about this doctrine that this was an issue in this case in front of the Court of Appeals. In district court, they did mention contradiction a couple times, and they did bring it up. But like, for example, one time they actually used the fact that he had different testimony in his affidavit to buttress their argument that there was a lack of personal knowledge. There wasn't really being seen for the contradiction, it was being seen to conjoin. There was another moment where they did talk really briefly about the fact that he had said in the early morning at one point, and then he said it in the afternoon the second. But to answer your question, the inconsistency affidavit rule, we don't believe it really falls within that, because if you look at the final question he was asked, he said, I don't recall any more at this time. He wasn't contradicting it. He answered the question honestly. He listed out people, and just so happened that afterwards he remembered some more eventually. I see that my time has expired, so we'd ask that this case be remanded to district court. Thank you.
I'd like to jump right into where you left off with Mr. Stoltze, and this court can determine this case on any legal theory that's supported by the record. And I would argue that we did bring up the contradictories in his affidavit versus his deposition testimony at the district court level and certainly at the Court of Appeals level. To invoke that contradictory affidavit rule, we only have to point out the inconsistencies, which we undoubtedly did several times. And additionally, he didn't just only say he didn't remember any more names, but to the very specific names that are named in his affidavit, he testified each time that he did not have firsthand knowledge or personal knowledge with respect to the circumstance of that individual's departure. That evidence is inadmissible. It is contradictory to his deposition testimony. You cannot get the inference that he wants you to get. It is based on speculation and mere suspicion, which he also testified to in his deposition. I additionally wanted to address this investigation and confirm with the court that the critical inquiry here is not whether or not Mr. Feeback actually meant that text message to go to Mr. Mulgrew, but it's whether or not the company had a good faith belief that he did, and it certainly did with the investigation that was conducted, wherein Mr. Charbonneau undisputedly interviewed Mr. Mulgrew, Mr. Carl, and Mr. Feeback. The company gets to make that decision, and they did here. And there's no evidence of any sort of age discrimination relating to his termination. Additionally, I wanted to address the superintendent paragraph in Mr. Feeback's affidavit that Mr. Stoltze pointed out, where a superintendent had used some cuss words screaming on the plant floor. These circumstances are not similarly situated at Mr. Feeback. While they may have had the same position as a superintendent, this superintendent, Mr. Lant, was screaming at a supervisor. That was down, not up, to Mr. Mulgrew. And additionally, nowhere in that paragraph is it identified that Mr. Lant, the comparator, said F you directly to that individual. I would argue that saying what the F are you doing is much different than a direct F you, which is exactly what happened in this case. I additionally wanted to address Mr. Stoltze's comment about Mr. Feeback's performance during his employment. This is not a performance review case. He was not terminated relating to his performance. He was terminated for his egregious text message that he sent to the general manager of the plant. And additionally, longevity in a workplace does not alter the at-will employment doctrine. Employees do not get any special circumstances because they've worked at an employer for a certain number of years. They're still subject to the at-will employment doctrine, which Mr. Feeback was in this case. Additionally, Mr. Stoltze brought up paragraph 22 with respect to Mr. Feeback's affidavit, wherein he talks about in his 30 years with the company, he'd estimate that hundreds of employees with management roles didn't survive to retirement. This evidence is pure speculation. There's no evidence to back it up. We don't know who these employees are. We don't know why employees left. He testified in his own deposition that he had no firsthand knowledge or personal knowledge with respect to departures, and that it was only his speculation, his belief that this was happening. This paragraph is clearly inadmissible and does not constitute evidence of intentional discrimination in this case. If there are no further questions, Your Honors, I would request that this court reverse the Court of Appeals determination on Mr. Feeback's age discrimination claim and affirm the district court's grant of summary judgment. Thank you.
The case of Feeback versus Swift Pork is hereby submitted, and court is in recess for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.